All right. Good morning, everyone. It's 9 o'clock. I'm Merrick Green. For those of you who don't know me, I'm the founder managing partner of General Counsel PC. Glad you could sign in today, whether via your computer or telephone, to listen to Lewis Rhodes speak on contracts during COVID-19 impacts on the coronavirus on businesses and business contracts. Please keep your phones muted as we go along. We will have a time for question and answers at the end of the program. So I think what we'll do is Lewis will speak for a few minutes. You can ask your questions either after he provides his presentation or during the chat function. You can ask questions then also. And since we anticipate having many people on this call, what we've done in the past that's worked well is we've gone through alphabetically and had people ask questions by their name. So that's worked well in the past. So without further ado, I will turn it over to Lewis. And thank you very much for calling in today.
All right. Good morning, everybody. I hope we're all surviving our respective quarantines. Today, I'm going to talk about our contracts and how the quarantines and the pandemic in general is impacting these contracts. We've been having a lot of clients come to us, trying to find room if there's a way to terminate contractual obligations. The good news is that there is. I mean, there's this longstanding concept called force majeure. I've been a lawyer for close to 20 years, and I've used force majeure more in I think the last 3 weeks than I did in the previous 19 years. So it's an old standing concept, but one that's getting a lot of retread. You see, I'm sure if you've been out following anything on LinkedIn, there articles on this are everywhere. Force majeure actually comes for a history lesson. It's an old, it comes from the Napoleonic Code way back when and made its way into English common law. So it's one of the few French terms we have in the legal community, and it literally means superior force. So there's these clauses in contracts, and if they're not in your contracts, they do exist in general common court law that allow parties to terminate obligations for events outside of their control. And outside of their control is the big key for a force majeure. If you enter into a bad business deal and your supply chain gets more expensive, or there's a regular run-of-the-mill business interruption, that doesn't trigger the clause. Obviously here with government shutdowns and pandemics and interruptions in supply chains, buildings being closed, we are way outside the scope of what a party can control. So force majeure provisions do kick in here. Just about every contract out there has a force majeure provision in it in one way or another. It may not say force majeure. Sometimes they're listed under impossibility. We helped a couple of clients out that had conferences that needed to be canceled, and the standard Marriott contract had what they called an impossibility clause. That's how they wrapped up their force majeure. Sometimes, if you read through carefully and look at the termination paragraph in a contract, it'll talk about terminating for cause for events outside of the party's control. That's a force majeure language. So it doesn't have to be, force majeure is not a magic word. It doesn't have to be in your contract. You just need to look through the contract closely. And you got to read the entire contract. People often will look at contracts, see one clause, and say, "Oh, this allows me to terminate." And you got to read the whole thing in conjunction. One of the rules of contract construction is everything has to be read together. So we got to look through a contract from beginning to end, look at several different provisions to see how these termination clauses kick in. And force majeure clauses can run the gambit. It's historically they've been looked at as a lot of legal boilerplate, and if you're in the regular services industry, not a lot of people put a lot of time and attention into their force majeure termination clauses. So, sometimes it could be two sentences, sometimes it can be a half a page paragraph. More detail is generally better. But the more detail there is in the contract, then courts and parties are going to look at what's specifically written into the contract, not necessarily what the common law standards are. So, this is one of those standard lawyer answers where when people ask questions about, hey, does my contract limit me to cancel? It really depends, and it depends on how the clause is written, and it's got to be looked at somewhat carefully. And the next obvious question is, does the outbreak trigger a force majeure instance? And frankly, in most cases, the outbreak itself does not. So there's been very few contracts I've seen that refer to the epidemics. Sometimes you'll see an epidemic or pandemic listed as a force majeure event. Oftentimes you don't. But what a lot of contracts have is they have things related to illegality, impossibility, or government actions and regulations. And so all these quarantines and all the orders of shutdowns are really the government actions are what triggering a lot of these clauses. Go back to the Marriott example we had, one of these conferences was out in Oregon, and as soon as the governor ordered a shutdown through the end of April, we were able to trigger the clause and get the client out of the contract and avoid a $600,000 penalty. So again, the key to that was not the epidemic itself or the disease outbreak. It was the government action. We also looked recently at a lease agreement for another client, and we were able to defer the start date of their lease for at least a month due to shutdowns out in Illinois. So the key is when you're looking at your contracts is you've got to see if there's clauses or language in there relating to government actions or general impossibility, and you've got to have an industry that's been impacted by the shutdowns and the quarantines. Probably the only good news of all the quarantines and shutdowns is pretty much every industry everywhere is being affected by one way or the other, which would allow you to trigger some of the termination clauses in your contracts. So now, when you get to force majeure, is not your monopoly get out of jail free card. There's generally certain standards in order to get it to trigger and work. And for force majeure, generally it has to render performance impossible or pretty close to impossible. Impossible does not mean difficult. All right. So if you have a contract and because of quarantines, you're supposed to deliver a good or a product, but you can't get the parts to make your product for an extra 3 or 4 weeks, that's not going to be enough to get out of the contract. You might get you'll get an excusable delay. You won't be penalized for being late in your delivery, but you still have to perform the purpose of the contract.
Hey, Lewis, we just had a question. So in that circumstance, how do you recommend the business to go about that situation? So, they're making widgets. They can't make the widgets. They have a contract that says they need to provide the widgets by, April 5th, but they can't. So how should they deal with that?
Yeah, well, the general rule of thumb is that communication is never a bad idea. So regardless of what your contract says, you should reach out to the other party. The good news again here is everybody knows what's going on, and unless you've been living under a stone, everybody knows the business interruptions. Most contract clauses that relate to termination for force majeure events require certain type of notice. And if you're going to be delayed, again, and you're going to rely on that clause to justify your delay, you generally need to notify the other party as soon as practical. So if you're finding out today that you're not going to be able to deliver something in 3 weeks, even if you think, hey, maybe you want to go ahead and provide notice. And the notice is a very good point, because a lot of times these clauses, if you don't provide notice in a timely manner, you're going to lose your right to try to exercise the force majeure clause. And that gets a little bit tricky right now, because as the governments extend shutdowns, hey, we're going to shut down for 30 weeks. No, we're going to make it 30 days. No, we're going to make it 6 weeks. And we saw this early on, especially, I'll go back to the conference out in Oregon. The governor kept incrementally extending the shutdowns. And it wasn't until she clearly shut it down that we triggered. But you have to be very careful that there's not an argument about, hey, you knew this 2 weeks ago and you didn't tell me. That can cause you to waive your right to trigger the force majeure contract. So bad news, and this is your general bad news is never delivered too early. The earlier you can discuss this with the other party, the better. And again, I'm going to go back to, we're seeing a lot of companies be a lot more reasonable than they normally are. Sometimes you just need to reach out and explain what's going on. And even if you don't have an absolute legal hook or an absolute legal right to terminate your contract, if you have a little bit of a hook and you go and make some reasonable requests, I think a lot of companies are working with their partners here.
And what we've also been just quickly talking to clients about, and if you can expand on this a little bit further, is we need to review those contracts, and clients have been bringing their contracts to us proactively to review, because each contract will be different. Each contract will have rights and obligations depending on the circumstances. And depending on the circumstances of the business relationship, there may be other arguments to make. So, for example, if you're providing widgets to a customer, and that customer then is using those widgets to do something else, build another product, there could be downstream losses of millions of dollars because you can't provide your certain product. And you need to think about those scenarios, because your client might then turn around and say, well, you're going to cost me $10 million if you don't get me this product in a timely manner. I'm not going to be able to fulfill my contracts, or my employees aren't going to be able to work properly because we don't have this component, or this piece of our factory is not going to be working, so we're going to have to shut down. You need to think through all those scenarios, and you need to do it proactively and as soon as possible.
Yes, absolutely. Like I said, notice and communication is important, and I'll keep hitting or stomping my foot on the notice issue. The last thing you want to do is have the ability to terminate a contract for the quarantines and shutdowns and miss the opportunity because you didn't provide the other side notice. That would be a difficult situation. And I'll put the further plug on. Come to us to let us look at your contracts first. We just had a client had an issue with a lease. The other side didn't have the building ready on time. He on his own went to the landlord and said, hey, I want out of my lease. And he didn't use certain language the right way. The landlord says, sure, we'll give you an early buyout. We're keeping your deposit. When the right answer should have been to tell the landlord, hey, you're in breach because you haven't delivered my space yet. I want my refund back and walk away. Sometimes, especially in legal and contractual matters, semantics are very important. So it's worth having us take a quick look through your contract to make sure that we're handling it the right way and using the right language out there. Now, we were talking about impossibility, and impossibility meaning impossibility. Some contracts will use the term impractical, vice impossible. And if you have that in your contract, congratulations. That's like winning the lottery on these clauses. Impracticability is a much lower standard than impossibility from a legal perspective. And what impracticability factors in is the economics as well. Impossibility doesn't mean, hey, I'm going to lose $10,000 on this deal. That's not an impossible situation. You have to lose the money, or you can be sued for breach of contract. Impracticability would be, hey, you know, we signed a contract to deliver these goods at this price. Now my supply chain has gotten limited, my costs have gone up, so I'm going to lose money on this deal, and I'm not going to. It's commercially impractical for me to go forward. So impractical vice impossible is a big difference. Doesn't necessarily sound like a lot, but legally it's significant. And the other issue on contracts is, even if there's no force majeure clause in your contract language, even if the force majeure clause isn't triggered, there's this long-standing common law concept called frustration of purpose. And ultimately, this is a good fallback option here. If you enter into a contract to do something, and for events outside of your control, you can no longer achieve the purpose of the contract, you can make a frustration of purpose argument to get out of it. We did this successfully for a different client on a conference. Their conference was scheduled, and there was no shutdown covering where they were. However, they were relying on a lot of keynote speakers that were coming from government agencies and universities. The universities and the government agencies all said, hey, our employees aren't allowed to travel until May 1st. So they lost like 65% of their keynote speakers and presenters for their conference. So we were able to, successfully go to the conference center and say, listen, we entered into this contract in order to host a conference with a bunch of speakers. Now none of our speakers can be here. We advanced the frustration of purpose argument, and it worked. Got us out of the contract. And that goes back to my point from a little bit earlier when I brought up the issues of people being reasonable. Generally you're going to get an argument or a fight if you make those kind of forays and say, hey, I'm my contract's now frustrated, I can't perform it. But there, the conference center knew what was happening. They're watching the news too, so they were willing to play the good guys and walk and let them out of the conference, and that was a win-win, because that organization then they just rescheduled, and they're doing their 2022 conference in the same venue. So instead of moving around like they normally do, since the conference center was partnered with them and did the right thing, they signed a new deal to do another conference there in the future. So I mean, what we are seeing is, you may have to push a little bit, but people are being pretty flexible here when they can, and there's usually a good business outcome that can be reached, even if you need to argue to terminate or end or otherwise cancel a contract. So the last thing I want to talk about from a contractual perspective is if you're signing contracts today. If you're entering into a new contract for anything, I'm gonna go out there and say you're not going to be able to rely on these on the quarantines and the COVID-19 pandemic as a force majeure event to a new contract. If you're signing a contract in the middle of this, you have a much harder argument to use the quarantines to get out of your contractual obligations. And along those lines, a lot of contracts wouldn't have covered the outbreak or the disease epidemic without government action or quarantines or otherwise. So as people are sending me new contracts that they're working on and looking to sign now, I'm paying a lot closer attention to the force majeure clauses, and I'm writing in some other events outside of the norm that appears in there. And at the bottom line, you want to always use the general catch-all event, other similar issues outside of the control of the parties. So if you're entering new contracts, make sure we're paying close attention to your your force majeure, termination, impossibility type clauses. And if there's not one in there, we probably want to add something relating to your ability to terminate, for world events outside of your control. So that's kind of the.
Lewis, quickly, I've gotten a few emailed questions to me. The first one was for businesses that have monthly contracts. So, contract for their copy machine, or a uniform company, or cleaning service that it's $2,000 a month. Sorry, I'm getting a bit of a. In that circumstance, what can the business do about those contracts if their business is shut down or they don't need the services anymore? You have a copy company that is you're paying $2,000 a month for 10,000 copies, but your office is closed now. What can you do in that circumstance?
Again, these are going to get to your frustration of purpose arguments, if nothing else. Even like for the sale and lease of goods, the Uniform Commercial Code has a clause in there that talks about frustrating the purpose of the agreement. If you needed to close your office for several months, or you just say, hey, I had 3 offices and I have to close 2 of them and limit my workforce because of the fallout of the quarantine, you're not really going into bankruptcy or shutting down, but you can use the frustration arguments to try to get out of, or just delay or limit for a couple of months your month-to-month contracts. A lot of the providers of goods, their contracts are, and I know some of the uniform or other providers, they can be very difficult to deal with. But there's even if there's not express language in the contract, there's legal provisions and common law provisions that give you the right to get out of these contracts without them hanging over your head. And a lot of companies that are really hurting on the cash flow, this can help. This can help out during the quarantine periods. And along those lines, the other thing I wanted to talk about is leases for office spaces. The leases are probably some of the most convoluted contracts written. They generally have some of the more robust force majeure clauses because it comes in a lot in properties. It's got to be a risk of a fire, water damage, or something. So if you have a lease, a lot of times there's there's language in there that provides for rent abatement to your lease space. There may be, depending on how it's written, there may be ways if your office building is shut down, or if you're inside of a mall and the mall is closed down, and it's closed down pursuant to state orders, or something along those lines, there may be language that allows you to get some rent abatement. Those will be a little bit more of a fight because a lot of times the building owners and the landlords, they have mortgage payments and other bond payments that they need to pay to their creditors. So the one area where we're finding where folks will push back is on the lease side. So if you do have a lease and you're thinking about trying to get out of making your rent payments for a couple of months, that is something I would absolutely say you should bring to us to review. Those can be pretty tricky. I mean, the lease agreement we looked at the other day was 55 pages, and there were clauses that referred back to other clauses and back and forth. And if if there's enough language in there, you can usually cobble together 3 or 4 different sections to come up with a good argument for why you shouldn't have to pay rent while you're not able to access your space and use it. Like I said, those are a little bit trickier, but it's possible, and it's worth taking a close look at them if you're shut down and your biggest expense is probably your monthly rent for your office space. Mm-hmm. So one last thing I wanted to cover briefly is for any of the government.
Lewis, we have some more questions, so
sure.
So you're aware.
Okay, we can keep going. I'll save the government contract stuff for last if you have more Q&A.
Yeah, we have some more questions that have come through. So one question was, school, and this is sort of obviously a little not more personal than business related, but someone has a contract with a daycare or a private school, and they're now having to homeschool their kids, or the daycare is shut down. Any rights there to get refund of monies paid?
Uh, Again, there probably is. I said it's if I mean if a school were to burn down or otherwise be unavailable, I don't think you would need to necessarily pay tuition. So we'd have to look at the even for daycares and schools, you generally have a terms and conditions or a contract when you sign, and there's probably force majeure language in that contract somewhere along the lines. And again, these will all be triggered, and even if they're not in the contract, they exist at common law. They'll all be triggered by the government actions and shutdowns. I mean, the government shutting schools down through June, and if you're paying tuition for private school for 3 months that they're not getting schooled, that's something to consider. Now, if the school's doing distance learning and other stuff, they're going to come back with an argument on that side. But every contract to one degree or another has clauses that are triggered by the quarantines. It's just a matter of the scope and the impact the quarantines would have on those specific contracts.
And another question was, they have a contract that is for a certain term, a 1-year term, a 2-year term. It's on hold. There can't be any performance during the quarantine period. What happens to that contract? Will it be extended automatically for the length of the quarantine? How should the parties deal with that?
That's a good question, and that honestly would come down to what the contract is for. I don't think you're going to say, "Hey, we can't perform for 3 months, so we're going to add 3 months to the end automatically." I think that's got to be a discussion between the parties. The force majeure clause may trigger for and let's go back to the cleaning contract. We have say you have a 1-year contract with your cleaning company to come and clean your office every day. Well, the office is closed for 6 weeks. So while the office is closed, I'm going to basically suspend my contract. I'm not going to pay you. But as soon as the quarantine is lifted and the office reopens, we'll go back to the contract. So in that case, it would be more like a suspension. You'd be using the force majeure clause to facilitate the suspension, but you don't have to terminate the contract. Because hey, we're going to want to go. We were happy with how things were working. We just can't afford to pay you for 2 months while we're not bringing in any money. So we want to suspend, and we'll kick the contract back off as soon as we reopen. Again, that's gets to your notice and your discussions with the suppliers or the other party. And that's I'll go back to that general point. A force majeure clause doesn't necessarily mean I'm terminating the contract. It can, and it really depends on what the contract is for and how it was supposed to be executed. The force majeure clause is kind of flexible. It can give you the ability to delay your performance. It can give you the ability to suspend performance or up to terminate. The way you look at it is, anything up to the termination is kind of fair game. So you can go to the other side and say, hey, I have no idea when I'm going to reopen. We're closed, and I may not ever be able to reopen. So I just want to terminate this contract. And if we get back to status quo, I'll call you then. Or you can say, hey, you know what? I have a right to terminate, but I don't want to. So I'm going to suspend the contract for 2 months, and then we'll pick it back up on June 1st. So you have a lot of options. Again, you want to communicate, you want to discuss with the other side, and there's a lot of facts and a lot of case-by-case situation to these deals. How much do you like dealing with the other party? What's on and on. It's a really case-by-case situation.
So that's interesting, because you think about all the expenses that a business has on an ongoing monthly basis. whether it's copy rental and service contracts to, a fleet of trucks, for a construction company or some other, service organization. And if all of that is shut down, or you have, phone service or computer service for your office, whatever the circumstances may be, really the business owners and executives need to look at all of those costs, those expenses, look at the contracts, and perhaps see if you're going to be shut down for a month or two, whether it makes sense to suspend them and use the contracts and force majeure or other contractual arguments to save that money.
Well, with Governor Northam just announcing that things are shut through June 10th, I think that changes the calculation for a lot of these contracts, right? If we thought this was going to be 3-4 weeks and we we're going to be back at it by the middle of April, I think there was a lot of looking at it one way. But now that you're talking about, it's already been close to 2 weeks, 2.5 weeks, and now we're looking at another 6 weeks. All those costs will start to add up pretty dramatically. So that the quarantine shutdown order all the way up through June 10th really does give a lot of companies a good hook to look through their contracts and either try to terminate them or otherwise suspend them and save some cash flow in the basis why their business is shut down or otherwise limited. And again, I'll circle back to the discussion on notice earlier, right? So the announcement from the governor came out just a couple of days ago. Most contracts have a force majeure provisions that have a notice requirement to them. Standard is probably somewhere in the 7 to 10 day period. So if this is something a company wants to look at, it's something they should look at sooner rather than later. Because if you get to the middle of April and then try to use this as hey, we got notice of this, we want to end our contract, you may get a little bit more pushback, because those are businesses too, and they're going to be going through the same economic calculations. Unfortunately, everybody else does, and the first companies that ask are probably more likely to get things resolved more user friendly than the 10th or 11th company that asks. I mean, if you want to just, be unfortunately practical about it.
Good. For folks that are on the phones, any questions that you want to pose? You want to start with folks A, B, C, D, E in the alphabet? Any questions? And any other questions from the folks on the phones? Open it up to everyone. Any questions? All right. Well, then, Lewis, why don't you I guess you were going to talk about GovCon a little bit, and then.
Yeah, the last thing I wanted to cover on the force majeure angle is for any government contractors who are out there. The one area where force majeure will not apply generally is going to be on your government contract. So that's the bad news. The good news is there are several FAR clauses out there in your contracts that relate to excusable delays. It depends on the type of contract you have on what clause it is, but they all basically say the same thing. They're kind of codified force majeure language. If something happens outside of your control and you can't perform your contract, you have a right to get a delay to your contract performance. So what those clauses do require, and I'll go back to, notice is never a bad thing, is you need to let the government know. If you're a government contractor and you're going to have a delay in performance for one reason or the other, you need to officially notify the government. Not like in passing discussion. You need to send them an official letter, say, to the contracting officer, spelling out why you're going to experience delays. So don't lose it. Don't fail to do that and then lose your right to your delay. Notify the government. The other big thing that we're seeing in the GovCon sector is government causing extra work or causing delays to the contractor. There are FAR clauses that say if the government does that and they shut down a site and you've got a fixed project for deliveries and you can't do it, those delays can be compensable. The government will always argue that they're non-cost delays, but if you've got to hold 3 people on the bench while the government is closing something, that's an expense, and that's something the government is on the hook for, be it through an REA or a claim. The best advice for government contractors is make sure you're closely documenting all of this stuff. If you are experiencing any additional costs due to government actions, delays, even something like, hey, you have 20 employees who work on site for the government. The government has shut down that office and is demanding your employees work from home or from another site. And if you are then paying, buying computers or buying printers or otherwise expending funds for those employees to work from home, that's a legitimate expense to charge back to the government. Because that was a direct cost to your contract that the government added. So make sure you're very closely documenting all that stuff. Make sure if you're going to buy a bunch of stuff for your employees to work from home, we're delineating who's a direct billing employee versus who's an indirect, and figure out how to make those claims onto your specific contract. So again, on the government side, like commercial, notice and communication, and then thoroughly document all the extra costs as you're, for anything related to government closes, shutdowns, changes to your contract. And that's kind of it from the government side.
Just quickly, Lewis, thank you. Any other questions before we go ahead and finish up? Well, I think that sounds like not. If you have any further questions, obviously you can contact Lewis or myself. But thank you everyone very much. Stay safe and good luck. Thank you. Bye.